Have you ever bought or sold something and wondered what Louisiana law specifically says about these transactions? In today's video, we'll explore Chapter 13 on sales from the 2025 Fundamentals of Louisiana Notarial Law and Practice, giving you clear and practical insights. So, what is a sale? Under Louisiana law, a sale is a contract whereby a person transfers ownership of a thing to another person for a price in money. Civil Code Article 2439 clearly sets out this definition. This means every sale involves three essential elements: agreement between the parties, the thing being sold, and the price. Let's break down these essential elements of a sale one by one. First is consent. Both the buyer and the seller must agree clearly and voluntarily. Consent must be free of error, fraud, or duress. Next is the thing. The thing is the object being sold. It must be specific or determinable. It could be movable, like a car or furniture, or immovable property, like land or buildings. Louisiana law mandates that the thing sold must exist at the time of sale, or at least be something that will exist in the future, like crops yet to be harvested. And last is price. The price must be determined or determinable in money. It can't be left vague or undefined. If no price is set, or if the price depends solely on the buyer's discretion, the sale is not valid under Louisiana law. In Louisiana, a sale is classified as a nominate contract. A contract that has a specific name or designation, such as a sale, lease, loan, deposit, or suretyship. Nominate contracts are governed by particular rules outlined in the Civil Code. While special rules exist, parties can adjust these rules within their agreements, provided such adjustments do not conflict with mandatory laws. In Louisiana, to enter into a sale contract, individuals must have the legal capacity to contract. Civil Code Article 1918 states that all persons who aren't explicitly prohibited by law have this capacity. Those specifically prohibited include interdicts, unemancipated minors, and individuals deprived of reason. Though these individuals can't execute the sale, they may still acquire property through a representative such as a curator or tutor, and they may dispose of their property with proper court approval, according to Civil Code Article 230 and Code of Civil Procedure Article 4271. Louisiana law presumes good faith in the purchaser, meaning the buyer believes the seller has rightful ownership. According to Article 1759, good faith is presumed unless the purchaser knows or should have known the seller lacks ownership rights. Civil Code Article 530 further explains that a person in possession of a corporeal movable is presumed to be its owner unless clearly proven otherwise. These presumptions protect buyers and reinforce confidence in transactions. Louisiana civil law is clear that if property is susceptible of ownership, it may be sold unless explicitly prohibited by law. Article 2448 emphasizes that all things, whether corporeal, physical, or incorporeal, non-physical, are eligible for sale. However, the law may specifically prohibit certain types of property from being sold. Interestingly, Louisiana law under Article 2450 permits even future things to be objects of sale. For instance, a crop that has yet to be harvested can be sold, provided it will exist at some point in the future. This sale typically hinges on conditions that the seller must meet. However, if the seller fails to fulfill the condition due to their fault, the buyer may have the right to claim damages. It's critical to note from Article 1976 that the succession, inheritance rights of a living person cannot be the object of a contract. Thus, an anticipated inheritance cannot be legally sold or encumbered. Article 2451 describes the sale of a hope. This unique concept refers to situations where a person sells a chance or opportunity. A common example given is that of a fisherman who sells his anticipated catch. Even if the fisherman ultimately catches nothing, the buyer remains obligated to pay, since the purchase was of the hope, not a guaranteed outcome. According to Article 2452, selling something that belongs to someone else does not transfer ownership to the buyer. Instead, such a transaction may serve as just title for purposes of acquisitive prescription, a concept discussed further in Louisiana civil law. Lastly, Article 2443 states that a person cannot purchase something they already own. Nevertheless, this does not restrict someone from buying out the rights of another party who may have or claim an adverse interest in the property. The perfection of the contract of sale refers to the point when ownership is transferred between parties. According to Louisiana Civil Code Article 2456, ownership transfers as soon as there is mutual agreement on the thing sold and the fixed price, even if the item hasn't yet been delivered and payment has not been received. For movable items, an offer to sell is considered accepted when there's agreement on both the item and price. However, the acceptance can include additional or different terms. If such acceptance is conditional upon the original offeror's agreement, then no contract is immediately formed. Without such conditions, the additional terms are treated as proposals for modifications. Under Civil Code Article 2456, the effect of a sale on third parties varies depending on whether the property is movable or immovable. For movable property, ownership transfers when the seller delivers the item to the buyer. For immovable property, Civil Code Article 517 explains that voluntary transfer of ownership for immovable property becomes effective between parties upon agreement. However, it only affects third parties after being properly recorded in the conveyance records of the parish where the property is located. Similarly, Article 518 clarifies that ownership of movables transfers voluntarily between contracting parties upon agreement unless otherwise stipulated. As we've previously mentioned, an essential element of a contract of sale is the price. According to Louisiana law, if there is no agreement on the price or how it will be fixed, there is no sale. Article 2464 highlights that the price must be certain or determinable, either by parties explicitly agreeing on an amount or providing a method to determine it. If the price is excessively disproportionate to the value of the item, it might be considered a donation. When parties agree to have a third person determine the price, and the designated third party fails or refuses to set the price, the court may intervene to set a fair price. Likewise, if there's no price agreed upon, or if it was left to be agreed upon later, and no subsequent agreement is reached, there is generally no sale. As per Article 2463, any expenses incidental to the sale must generally be borne by the buyer, unless the parties agree otherwise. Delivery is essential for transferring ownership of the sold item to the buyer. Article 2477 states that delivery of movable property typically occurs by physically handing the item over. However, parties can agree upon other methods, like giving keys to a location or transferring documentation. For incorporeal movables, such as stocks or bonds, delivery occurs by transferring the instrument itself or through an agreed-upon method. Article 2483 indicates that unless otherwise agreed, the seller bears the cost of making delivery, while the buyer covers the costs of receiving the item. If the buyer fails to accept delivery, they may be held liable for the seller's incurred expenses and potential damages. The delivery should occur at the agreed location, or absent an agreement, at the place the item is located during the sale. Article 2467 highlights that the risk of loss transfers to the buyer upon delivery, unless stipulated otherwise. Even in cases where delivered goods are non-conforming, the risk transfers unless the buyer formally rejects the delivery in a timely manner. The Civil Code clearly outlines seller obligations. These include delivery of the thing sold, warranty against eviction, ensuring buyer's peaceful possession, and warranty against hidden defects in the things sold. Buyers have responsibilities too. These include paying the price at the agreed time and place, and taking delivery of the things sold. Redhibition refers to hidden defects that make the thing useless or diminish its value. The seller is legally obligated to disclose known defects. Buyers discovering hidden defects after the sale may have the right to a reduction in price or even cancellation of the sale. Louisiana notaries must ensure compliance with formal sale requirements, especially for immovables. Immovable property sales must be made through authentic act or under private signature duly acknowledged to be effective against third parties. To sum up, Sales must have consent, an identifiable thing, and a clear price. Both buyers and sellers have specific obligations. Sellers provide warranties against eviction and hidden defects. Immovable property transactions have additional formalities for legal recognition. Understanding these key points about sales ensures your transactions are smooth, legal, and protected. This concludes today's video. Thank you for watching Chapter 13, Sale Explained. Be sure to like, subscribe, and leave comments below on topics you'd like me to cover next. I'll see you in our next video.